When Josh first approached me and asked me to present at this CLE, which is something that I've gotten used to doing quite a bit over the last few years since joining the bench, and something I enjoy doing very much, getting out in the bar and talking typically nuts and bolts stuff about the law. Oftentimes us appellate judges, or is it we appellate judges, get the duty of providing case updates. And I know that you have some case updates following my talk. But what I told Josh is, I would love to be there, but I'm not giving a case update. You have to let me talk about something that I find really interesting. And he said, of course, that would be great. So I'm going to talk about one of my favorite Kansans, and a man who I think history, and legal history in particular, has neglected for far too long. And I would like to see a sort of renaissance of brewer studies, if you will. And if I can play some small role in kicking that off or in encouraging that, I want to do so. So that's why I picked Justice Brewer as the subject of this morning's talk. Here he is, you can see him on the screen there. Brewer was, of course, a member of the Kansas Supreme Court who went on to serve for 2 decades on the United States Supreme Court, the only Kansan to do so. So obviously, we have special ties to this man here in Kansas. But beyond that, he is an extremely important figure in our national history, in the development of our national jurisprudence and our understanding of our constitutional structure, and in particular of this very controversial concept of substantive due process. So that's why I entitled the talk as I did. In reality, that title, A Kansan on the United States Supreme Court, Prairie Roots of Substantive Due Process in the Lochner Era, is far too grandiose and probably far-reaching and ambitious for a 50-minute CLE. There's no way that I can really fully do justice to that. Probably couldn't in a full-length law review. I hope that it at least has piqued some people's interest, though, in, as I said, one of our most neglected great canons. So my goal really is quite a bit more modest than the title here suggests, and it's simply to provide to an audience of Kansas lawyers and people interested in Kansas law a reintroduction of Brewer. Who is this guy? I would wager that prior to hearing about this CLE, most of you, if I said David Brewer, probably wouldn't have any idea who he was. Probably would say, I've never heard of that guy. So I want to reintroduce Brewer to a modern legal audience, and I want to suggest possible ways that a study of his life and of his jurisprudence, which really arises out of the birth of our state. It really arises out of the formation of the state of Kansas. Would give us clues, or could give us clues, to help us understand and come to a greater understanding of our current constitutional moment. So, that's my more modest goal, and even stating it as a more modest goal, you'll be able to tell that there's some ambition there. So we'll see how we do. Before I get going, any talk like this is really deeply indebted to a whole host of secondary sources. In this PowerPoint presentation, I am following a Supreme Court Justice's rule of citation, which is extremely relaxed. But I do think it's important and certainly appropriate to acknowledge the primary sources which I rely on here, just so you know. And really there are two authors in particular. The first is Michael Broadhead, who's written the only biography of Brewer in existence. It's a good resource for Brewer, the life of the Supreme Court Justice. But secondly, Professor Hilton, who's written numerous articles on the career and thought of Brewer, And so anytime I don't specifically cite to a source, I want to just make the statement that there probably is material that comes out of one of Hilton's work. Here's what Hilton says about Brewer, which I think this is very true, having kind of made Brewer a hobby study of my own. It's that Brewer's career offers an intriguing case study of how liberal, quote-unquote, liberal ideas or ideals of one generation play themselves out over the course of a subsequent generation characterized by profound cultural and political changes. And that is very much true of David Brewer. That's sort of the burden of my talk this morning, is to at least begin to defend this statement of Professor Hilton. Because as you'll see as we go through this, the central theme that I want to touch on, the question I want to ask really is, was Brewer a conservative or a liberal? And I say the question with a hint of a smile because, of course, the answer is, or at least the answer that I want to reach, is that it's very difficult to say using our modern definitions of those words. And I think that as we proceed through this, we can see how the thought and life of a guy like Brewer can really challenge some of our assumptions about what it might mean to be a judicial conservative versus a judicial liberal, and shake up those categories in ways that I think are healthy. Healthy at least in the sense of it gets us to think past our stereotypical categories, which sometimes can be blinders, preventing us from seeing new ways of looking at a legal problem. So that's the challenge of my talk that I set to myself. So who was Brewer? Just I think it's important to give a brief sort of biographical sketch. Brewer was the son of Congregationalist missionaries in Turkey. He was born in 1837 in Turkey on the mission field. He returned to New England as a young boy and grew and was educated there. He graduated from Yale in 1856, and then he went on to Albany Law School. As soon as he graduated from law school, he had a little hiatus in Colorado during the gold rush, trying to extract gold and become rich, and he was a complete failure as a gold miner. So that didn't last very long, and then he really settled into his legal career in 1859, the same year the Kansas Constitution was drafted at the Wyandotte Convention, and Brewer was in Lebanon. That's where he moved to be, really specifically, I'll talk about this in a minute, to be part of the abolition struggle in Kansas. So he set up his legal office in Leavenworth in 1859. From 59 to 70, Brewer was very, very active, both in the law in Kansas and in Kansas politics. He, of course, practiced law. He became the superintendent of schools in Leavenworth, and he ended up serving as a district judge for a period of time. He did lots of other things as well, but those are kind of the highlights. Then he was elected to the Kansas Supreme Court in 1870. He served on the Kansas Supreme Court for 15 years until 1884, when he was put on the 8th Circuit Court of Appeals, and then, of course, appointed in 1890 to the United States Supreme Court, where he served for the last 20 years of his life. He died rather suddenly at I think the age of 72 in 1910. His tenure on the United States Supreme Court almost perfectly overlaps the tenure of Chief Justice Fuller. So this period of the United States Supreme Court, typically referred to as the Fuller Court, Chief Justice Fuller served from 1888 to 1910. So Brewer's career is really the career of the Fuller Court when we talk in terms of the United States Supreme Court. Just a few sort of humanizing points. I'll go back to these pictures before I tell these stories. So as we'll see in a minute, Brewer's reputation in the 20th century, the 20th century was not kind to David Brewer, put it that way. And one commentator that I read actually said that he thought one of the reasons that the 20th century was so unkind to Brewer is because of the way he looked. And so that's one of the reasons I picked that portrait there on the right. He was sort of the quintessential grumpy old man. representative of wealthy industrialist America, the rich guy who wanted to pull the ladder up and not let anybody else. So that's, I don't know if you think that's true. He does kind of look old and fusty there in that picture. But I put the other painting there because this is a younger brewer in his Kansas days. And he doesn't look so bad in that picture. I don't think. Looks like a guy you could probably hang out with. And some of the stories that are told about him evidence that as well. So in his very first argument as a young lawyer, actually not as a young lawyer, but as a lawyer, his first argument in front of the Kansas Supreme Court came actually after he had served as a district court judge. And the plaintiff in the case that was proceeding to the United States, or to the Kansas Supreme Court, hired Prairie to represent the plaintiff. The interesting twist is that this was a case in which Brewer had presided over as a district judge and had actually ruled against the plaintiff. And so in his, which of course that would never happen today, right? Judicial ethics have come a long way since then. But when he appeared in front of the Kansas Supreme Court, the story goes, he said that he acknowledged it was a little odd that he was here representing the plaintiff in a case in which he had ruled against the plaintiff. So he's arguing against his own opinion. And he allegedly said to the Kansas Supreme Court, well, everyone else has complained of my decision, so I don't see why I should complain of it. So, he had a sense of humor. He took great delight in the fact that his last name was Brewer in an era of prohibition. And he was, in terms of, as a policy matter, he was a prohibitionist. He agreed with that policy perspective, but he kind of liked to tweak the prohibitionists, especially since his last name was Brewer. And when he was appointed to the United States Supreme Court, he was being introduced at a function in D.C. where there was lots of alcohol probably being served, and the joke was that he was appointed as a brewer, put a brewer on the Supreme Court so that all the justices could be full. And I don't really get that joke exactly, but it's the setup for this, which is Brewer then stood up and said, well, I'll do my best to make my fellow associate justices full, but no matter how much I succeed, the Chief Justice will always be fuller. Come on, Fuller. Chief Justice Fuller. Anyway, so he liked puns, apparently, bad puns. But clearly this is a guy who enjoyed himself and probably didn't take himself as seriously as his later reputation might suggest. So here is the Fuller Court. I don't have a pointer, but you can see Brewer there, seated, second from the right. There's Fuller in the middle, Chief Justice. That's Rufus Peckham, seated next to Brewer. And then the other sort of giant on this court is Oliver Wendell Holmes, who's standing between Brewer and Fuller, there with the very full mustache. That's from 1907. Here's an interesting picture. The only one I could find of the Fuller Court is actually sitting on the bench. This is from an oral argument that was actually presented by Clarence Darrow in a labor law case. But here you can see, and someone's on the photograph, they've written the names here. So Brewer, and I neglected to mention Justice Harlan as well, who is an important figure in the court. Holmes is the junior justice all the way down to the end. So what do we know about Fuller? What characterized Fuller? And I want to give just a snapshot of that court to sort of situate Brewer in his time on that court. And of course, the Fuller Court is known as one of, if not the most conservative Supreme Court in our nation's history. It came to define an era, the Lochner era, which has since been repudiated but remains exceptionally controversial in our jurisprudence today. And as you'll see here in a minute, Lochner continues to be a source of lots and lots of discussion among scholars, academics, judges, etc. So this is the Fuller Court. It's a court that, in terms of the later criticism of it, was a very bad court. It's a court that does not have a good reputation. And Brewer was probably the leading intellectual light on that court in terms of developing its jurisprudence, etc. And of course, the titular case, the Lochner case of that era, is one, I don't know how familiar you all are with it, but a very brief sketch. This is a period of progressive reform when states and the federal government are trying to regulate the marketplace and to eliminate abuses of labor, or at least societally perceived abuses of labor, and do things like impose minimum wage, maximum hours laws, workplace safety laws. The whole progressive workplace agenda was coming into fruition. And Lochner was a case in which the state of New York had passed a maximum hour laws for New York bakeries. And that ended up being challenged, and the Supreme Court struck down a state law that's important, using what ended up becoming known as substantive due process, but using an argument from the 14th Amendment saying essentially that New York had overstepped the bounds and could not mandate that workers in New York bakeries could not work more than X number of hours per week. So that's the Lochner case, which seems maybe somewhat innocuous. It's, at least when measured against the kind of controversial cases that we're used to talking about today, this was it's just a sort of workplace regulation case. But it generated a massive blowback on the court. And of course, that blowback ended up resulting 25 odd years later in FDR's New Deal Court and the whole sort of progressive agenda that followed. So again, just to summarize, the critique of Lochner was that these judges were kind of in the pocket of big business. They were just carrying the water for the rich industrialists. They had found these substantive property rights or contract rights in the Constitution, and in fact, those rights really aren't there. That these judges had aggressively, in a sort of activist way, struck down democratically passed economic regulations, and those regulations had been implemented for the benefit of the people, and these judges were standing in the way of that because they were protecting the moneyed interest. So that's the very broad sketch of critique of Lochner. Here's how some modern day scholars have recounted the critique, and I've put it up there. And they just say the critique of Lochner during the progressive era was relentless and multifaceted. Progressive critics attacked it for improperly intruding into the realm of the legislature, for crafting a malleable jurisprudence that allowed judges to import their political values into the Constitution, for enforcing rights that were not enumerated in the text, and then coalescing around the assertion that the era of Lochner lay in its failure to defer to the judgment of the elected legislature. Those critiques, I'm guessing, I'm hoping, should sound really familiar to you. We hear these critiques a lot, probably not associated with Lochner. But that's the progressive critique of Lochner. And then I just added here that Brewer didn't write the majority decision in Lochner. Rufus Peckham wrote that. But Brewer, in his day, was understood to be the leader, as I said, the intellectual leader of the Fuller Court, and was the deciding vote in Lochner, which was a 5-vote decision. Hilton says, few justices in the history of the Supreme Court of the United States have been more frequently disparaged than David Josiah Brewer. I think that that's probably true. I think Hilton's judgment is probably correct in that matter. And the reason is this. The reason is Lochner. The reason is that Brewer was seen in his day, certainly, as the driving force behind the Fuller Court's quote-unquote activism. So Theodore Roosevelt didn't like Brewer very much. Roosevelt, you recall, was the progressive reformer, Republican progressive reformer. According to Roosevelt, Brewer was a menace to the nation who had a sweetbread for a grain. And he was a corporation judge whose presence on the bench was a source of grave discredit and weakness to him. So the days of criticizing judges, presidents criticizing judges, is not new, apparently. Hilton collects a whole slew of really negative scholarly judgments of Brewer. These are all roughly mid-20th century. Brewer is a leader of the ultra-conservative economic laissez-faire advocates. He's one of the tough-minded twins of ultra-conservatism, the other being Rufus Becker. He's the William Douglas of the right. And if you don't know William Douglas, that won't make much sense, but William Douglas is the guy that conservatives love and hate for sort of being a free-form judge who could kind of do whatever he wanted, but for liberal laws. So again, that's what that means. Firm believer in laissez-faire, old laissez-faire advocate, vigorous proponent of judicial sanctions for laissez-faire conservatism, conservative commitment to a rigidly circumscribed concept of government regulatory authority. And I love this is my favorite one. Brewer's thought turned in upon legal principles instead of expanding outward to an examination of the economic and social conditions to which laws intended to apply. And you could be forgiven for scratching your head a little bit and saying, well, what else should a judge do other than turn in upon legal principles? But that's what one scholar, a judge, was wrong with. Here's sort of the summation of Brewer's 20th century reputation from a historian named Arnold Paul. Brewer held to a strictly conservative, sometimes reactionary position on the court, opposing firmly the expansion of government regulatory power, state or federal, an outspoken and doctrinaire conservative who made little pretense of judicial self-restraint, and few compromises to court consensus. He was dogmatic, ultra-conservative, that word shows up over and over again, in a wide spectrum of social, political, and judicial matters. It wasn't, of course, until the Warren Court in the mid-20th century discovered that it was, it being the liberal bloc on the court, was in complete control of the third branch of government, that so-called quote-unquote liberals rediscovered the idea of fundamental rights and really substantive due process. The Warren Court gave a rebirth to the notion of substantive due process, only this time it was articulated in a way that, again, purported to make constitutional sense because it left unmolested the government's ability to regulate most areas of our lives. And it simply constrained the government from intruding upon what was viewed as a private sphere, which was deemed to be fundamental. And so you have a whole panoply of rights that are articulated in the Warren Court era and then subsequent courts, which are predicated on this idea of substantive due process. So by the time Reagan is in the White House, of course, we have kind of a complete reversal of the progressive critique of Lochner. That is to say, when Reagan appointed his Attorney General Ed Meese, who I think, am I correct, one of the founders of the Federalist Society? By that point in time, an activist judge was a quote-unquote liberal. And an activist judge was a judge who desired to expand the realm of social rights in derogation of the democratically expressed will of the people. And a quote-unquote conservative judge was one who would exercise restraint, who would permit the political branches a wide degree of latitude to regulate all manner of things, provided that they did not cross what were very clear, textually specified, and enumerated boundaries. At that point in time, in the 80s, we could get another quote-unquote ultra-conservative judge, Judge Robert Bork, who could say that this of Lochner is, quote, an abomination. It is the symbol, indeed the quintessence of judicial usurpation of power. And that has certainly continued through to this day. Just a couple years ago, in his dissent in the Obergefell case, Chief Justice John Roberts used Lochner as a club with which to hit the Obergefell majority for doing exactly what the 20th century judge Lochner was doing. And here's what Roberts wrote, quote, by empowering judges to elevate their own policy judgments to the status of constitutionally protected liberty, the Lochner line of cases left, and here he's quoting Leonard Hand, the Lochner line of cases left no alternative to regarding the court as a legislative chamber. And again, I think that this kind of discussion should be very familiar to us if we are at all follow today's judicial debates. These lines of judicial conflict are the lines that we are very familiar with. They've become very entrenched in our politics. In recent years, there's been a sort of boomlet of Lochner rehabilitation or revisionist history. A number of scholars have taken on the task of trying to rebut and resurrect, if not the full jurisprudence of the fuller court in the Lochner era, at least an understanding of the rulings as they occurred at the time they occurred, and to say they're not so far out of bounds as we have thought them to be. One of the premier scholars doing this is a guy named David Bernstein. This is the cover of his book, Rehabilitating Lochner. It's a fascinating read if you like that kind of stuff. The only reason I have this up here has nothing to do with the book or the content of the book. It's because of this cover art. Because Brewer's not on it. That upsets me. I think the cover art is completely wrong here. What this shows is Rufus Peckham laying low Oliver Wendell Holmes in the boxing match. And that makes sense because Peckham authored the majority opinion. But I just put it up there as a little note to say, even in a period of a certain segment of scholars trying to rehabilitate Lochner, Brewer still is getting the short shrift. He's in a scholarly movement that really ought to be rehabilitating Brewer. He's still sort of the forgotten justice, which I think is interesting. If anyone's career really deserves a closer look, if we're going to take a closer look at the Lochner era, again, I would say it's the career and life of David Brewer. And one of the reasons is not just because he's a Kansan, and I have a partiality in that direction, but really because if you look at his life, it does not make sense. It does not fit with the historical judgment of Brewer. There is what appears to be a deep contradiction in Brewer's life. And to me, anytime I see that kind of a contradiction, it at least offers a clue to me that there might be some fruitful lines of inquiry here. Because maybe the frame with which we are using to judge this historical period is off. At least that's the question that I want to ask. Is the frame that we're using to judge Brewer off a little bit? And the reason I think it might be off is because of Brewer's life. And so I just want to give you a sense of the contradiction. Brewer, 20th century, reputation, bad guy, bad judge, ultra-conservative, etc. That was not at all how he was viewed during his lifetime. He was well known as the most popular Supreme Court justice. In fact, in his era, if you were to ask, take one of the polls that is common now, and ask American citizens, which Supreme Court justice do you know, Brewer would have easily been at the top of that list. These are just a few of the statements that were made by the national press when Brewer died. New York Times, of all the justices on the Supreme Court of the United States, David Brewer was the best known to me. Chicago Trib, Justice Brewer's death is a big loss to the public in other ways than as a member of the bench. He was the only member of the bench who freely expressed his opinion on large public questions. Washington Post, Brewer became the embodiment of the ideals cherished by the people and respect to those chosen to sit in the temple of justice. His public monument is his own pure fame as a judge. He became like one of the fathers of the Republic. His voice was the voice of wisdom, understanding, and patriotism. It's a little hard to read this and try to figure out how this person could be so completely forgotten today. But when he was alive, this was not the case at all. He was esteemed by the public, and obviously esteemed by the authors of obituaries in the national press. He was often known as the people's justice. Doesn't really fit with the characterization of an ultra-conservative reaction. Part of the reason he was so well loved is likely because of the way he conducted his life and the things that he cared about. Brewer was a progressive reformer. There's no two ways about it in terms of the things that he cared about and he spent his life fighting. Every sort of celeb cause of the progressive era, Brewer was front and center pushing. Of course, he cut his teeth in Kansas as an abolitionist. He was for the free rights of labor. He was a very early proponent of universal suffrage. He wrote some of the earliest decisions when he sat on the Kansas Supreme Court, upholding and supporting a woman's right to full political participation in our democracy. He advocated on behalf of prison reform. He did a lot on behalf of Chinese Americans. He actually was a conservationist. He talked a lot about conserving public lands. As the first superintendent of the Leavenworth School District, he created and insisted on creating the first public schools for African Americans. He advocated on behalf of the disabled. He was even in matters of international affairs. He was a dove. He was a peacenik, what we would call him perhaps. He argued in favor of international arbitration, which was a big issue in the time. Really those ideas ended up creating the League of Nations and ended up leading to the United Nations. He was for massive disarmament amongst the countries. So again, just to give you a sense of who this guy was, if this is your political resume today, it gets really hard, I think at least, to fit you in the, again, quote unquote, so-called conservative box. So how do we resolve these contradictions? I think that when viewed from within this sort of what I've described as a comfortable spectrum of conservative versus liberal jurisprudence that we've grown accustomed to, Brewer's career really appears to be riddled with these contradictions, or perhaps outright hypocrisies. I think it's really the burden of my talk here this morning to just suggest that if we step outside that spectrum, there might be a compelling way to understand Justice Brewer's seemingly contradictory career in the law as actually not contradictory at all, and in fact as pretty cohesive, adhering around a pretty cohesive set of values and principles. It's just a set of values and principles that our habits of viewing these things does not really give us direct access to. So to provide a start to answering that question, that's really the task that I've set for myself today. And as you can already tell, I really think the answer to the question, is there a different way of viewing this, is yes. I think getting to that answer, though, is a rather complex, requires following a rather complex path. We have to kind of untangle and unwind some constitutionally and historically tangled threads. We have to talk about our fundamental understanding of the meaning of liberty, of the purpose of the state, and the role of judges in a state. And we have to kind of back up from the way those things are typically understood today and try to understand how Brewer looked at those things. And in doing so, I think that we can probably gain a better grasp on how we moved from there to here. And as I mentioned earlier, we may be able to sort of shake up our habits of thinking about quote-unquote conservative versus liberal judges and perhaps allow for some fruitful uptake of those ideas. Well, that's where I'm headed. Brewer had two really great influences in his life. And the first was his sort of reformist New England Christianity. As I said, he was the son of a Congregationalist minister, and he himself remained a Congregationalist his entire life, and was a proponent of that sort of very progressive and yet muscular Christianity that was preached in the latter half of the 19th century in New England, and particularly by a guy named Theodore Wolsey, who was a professor at Yale, and Brewer really became his protege. Wolsey was extremely influential on Brewer. Here's what Wolsey said about society. Society was never meant to be the principal means by which the perfection of the individual was to be secured, but only the condition without which that perfection would be possible. I think I have a typo in there, but if he thinks, it should be if he thinks the end of government is to support him, to point out to him ways of industry, to lead the way in every enterprise. He remains a dependent, undeveloped citizen. He's not a free man in spirit. So that sort of summarizes this sort of aggressive reformist Christianity. Here's what Hilton says. Wolsey believed moral choices were genuine only if they're freely made by the individual. Consequently, to interfere with the right of choice on the grounds that the state or the majority knew better than the individual was to frustrate God's design. So this is a form of Christianity that exalts the individual conscience over almost everything. Brewer would later echo this when he said, majorities cannot be trusted to be wiser than individuals, because the Almighty is wiser than even such a majority, for he has decreed it best for man to leave each free to work out his own salvation. And just moving along pretty quickly here, the other great influence on Brewer was, of course, Kansas, the struggle for and birth of our state. If you read through the early biographical material of Brewer, you'll find that when he was a young boy, his sister wrote a lot about this. He became pretty obsessed with Kansas as a teenager in New England. He became an ardent supporter of the abolitionist cause and of a free Kansas. And he was committed long before he was of age to moving to Kansas and joining the struggle. So his sister says that she knew at a very early age that Brewer was headed to Kansas. And in fact, he did. Now, he did have a little detour in the gold rush. But as soon as he got out of law school, essentially, he hit the ground in Leavenworth in 1859 with the express intent of being part of this struggle for freedom. And that's how he viewed himself, and that's how he viewed the state of Kansas. He gave a pretty remarkable speech at the Kansas Bar Association in 1895 called Some Thoughts on Kansas, and I've excerpted it a few times here. I know the print is very small there, you probably can't read it. I'll do my best to read it too. Here's what he said about Kansas. The second commandment has been the inspiration of Kansas. Thou shalt love thy neighbor as thyself. Interprets her life. Humanity rather than its creator more than God. Quote, liberty, equality, and fraternity has been her watchword. That a more abundant liberty shall prevail, and that every individual shall be enabled to work out his own destiny. You'll begin to see themes repeated throughout Brewer's work. Work out his own destiny, unhampered by shackles and unrestrained by bondage, has been her constant ideal and unfailing purpose. Freedom has been the single golden thread running through all the shining fabric which her heroic sons and daughters have been weaving these 40 years on the loom of history. And now the question of profoundest import is, has Kansas fulfilled her mission? Has her intense enthusiasm for liberty spent its force? Is the second great commandment here passing into innocuous desuetude? Is she to cease her aggressive and progressive life, to drop into the easy ways of those who sow and reap, buy and sell, and get gain, and thus live only to enjoy the good things of earth? This does not, by the way, this does not sound like a industrialist, a capitalist. I just think that judgment of Brewer cannot hold up when you take a closer look at what he cared about. He goes on to say, I believe not. Never has there been a time when the ancient saying, eternal vigilance is the price of liberty, was more imperative than it is today. Never has there been a time when the inspiring thought written into the Declaration of Independence of inalienable rights which each individual has to life, liberty, and the pursuit of happiness was in greater peril than at the present moment. While we have gotten away from the days of slavery and hear no longer the crack of the whip, we're steadily dropping under the domination of the policeman. We're in growing danger of having our lives wholly regulated by his imperative, move on. So here you start to see the hints of Brewer's concern for what in his jurisprudence, in his opinion writing, will become his concern to limit the government's police power. And it really arises out of not only his Congregationalist commitments, but also his early commitments that he formed in Kansas. I think I'm going to skip this for time's sake, but this is a great quote also from Some Thoughts on Kansas. And here Brewer, this could be uttered by a modern day politician. And again, I don't know if you have it in your materials, but to sum up, this is a diatribe against government overreach, is what this is. And it's really important to know, again, I won't read it all, but he starts it out by saying, it's undoubtedly true that man, by entering into society, relinquishes some of his natural, unlimited freedom of action, and must so regulate his life so as not to injure the well-being of those about him. If there's one sentence that captures Brewer's jurisprudential foundations, this is it. And it's really tied to the Declaration. It's tied to the Declaration's mandate that all are created equal with these inalienable rights. But for Brewer, what that means, what he's talking about here, is that individuals start in a natural state of what he calls unlimited freedom of action. And they give up some of that freedom to a societal government for the common good. That's what he's saying. But he goes on to say there are limits to that. The Declaration, in describing who people are, does not assume that people give up all of their pre-political rights, their rights that existed prior to the existence of the They only give up that measure of rights which is reasonably needed to ensure the common good. And this is sort of it becomes the philosophical foundation on which Brewer would develop his jurisprudence of the police powers. And that's kind of what I want to move to conclude the talk, is to ask the question, how does all of this, and again, I've only given the briefest of thumbnail sketches, how does this manifest itself in Brewer's actual decision-making? How does what I've just described lead to Lochner, which in turn leads to this contradiction where Brewer is both called an ultra-conservative, but he was the people's justice at the time he died? How does that make sense? Well, I think the beginnings of at least trying to make sense of that lie in understanding Brewer's jurisprudence of the police powers. Sorry. So here is, again, I'm sorry the type is so small, you probably can't read that. This is from an article that Brewer wrote in 1908, 3 years after the Lochner decision. He titled it "A Legitimate Exercise of the Police Power in the Protection of Health." And this is, so far as I can tell, his most direct defense of the Lochner decision. And here's what he writes, and I will try to just read through this. Suppose the legislature should conclude that the moral condition of the community would be improved if no one were permitted to work over 4 hours. Possibly it might be right. The extra hours might be passed by the employee in improving his mind, in associating with his family, and to his advantage. Or on the other hand, they might be spent in dissipation. Who can tell? But these are questions which, and I'll just pause here and sort of annotate this. In our common way of thinking about things these days, we would probably characterize that question as a policy question. And at least consistent with the Borg and Roberts quotes that I read earlier, the view of judicial restraint would be that the policy questions ought to be left in the realm of democratic political decision. But Brewer said, that's what Brewer's talking about. What if they said you can only work 4 hours? And then he says these are questions which, if the occupation is not freighted with a special danger to the individual or to those dependent upon his action, these are beyond the power of the legislature to decide. Here he's saying, he's making a police power type argument. He's saying, look, the legislature only has power delegated to it in our Constitution. Again, relying primarily on the language from the Declaration. It only has the power to impose regulations that are reasonably calculated to improve the public good or to protect the public health. And if you can't point to anything, any purpose for this law that accomplishes those ends, it's illegitimate. The legislature doesn't have that power. We have constitutional provisions which no legislature can ignore. Interestingly, he then says the Declaration of Independence, which is not in any of our constitutional provisions, but he says the Declaration of Independence, which is the Magna Carta of our system of government, speaks of unalienable rights of life, liberty, and the pursuit of happiness. This means the right of each one to pursue happiness according to his own ideas of what will bring happiness. That is remarkably prescient and reminiscent of some much celebrated and much derided lines written by Justice Kennedy in a variety of cases, starting with Planned Parenthood v. Casey, where he talks about the central sort of gravamen of American existence is the right to define your own destiny. Brewer goes on to say, if he thinks that working for 12 hours is better for him and will inure to his happiness to a greater extent than labor for less time, and his work is not attended by any special risks, then he has the right to work for that length of time. And again, he's not really he's using the word right, but he's not really talking about a right the way we think of a right. It's not like a right to abortion or a right to have a lawyer when you're charged with a crime. He's really talking about a right to be free from government interference. Not particularly a right to work for any X number of hours. And then again, the employer has a right to contract with him. And then it says we had a case, which came before us. Interestingly, either he or the transcriptionist misspells the case. Probably in 1908, Lochner was just one of, hundreds of cases. It probably didn't have the same resonance that it does now. I don't know, I'm just speculating on that. But anyway, he talks about Lochner. It appeared the legislature had passed an act prohibiting bakers from requiring any of their employees to work more than a certain length of time. And then he quotes from Lochner. Statutes of the nature statutes of the nature of that under review, limiting the hours in which grown and intelligent men may labor to earn their living, are mere meddlesome interference with the rights of the individual, and they are not saved from condemnation by the claim that they are cast in the exercise of the police power upon the subject of the health of the individual, whose rights are interfered with, unless there be some fair ground, reasonable in and of itself, to say that there is material danger to the public health or to the health of the employee, if the hours of labor are not curtailed. If this be not clearly the case, the individual whose rights are thus made the subject of legislative interference are under the protection of the federal Constitution regarding their liberty of contract as well as person, and the legislature of the state has no power to limit their right as proposed in the statute. And then here's Brewer's commentary. Why should it not be so? Here is a man, strong, vigorous, healthy. Why should he not be permitted to contract for more than 8 hours of labor? For 9, 10, or a dozen if he wishes. There's scarcely a man in charge of any department in Washington who does not work over 10 hours a day. There's not a justice on our court who does not work longer. And all of us look reasonably ill. The Declaration of Independence and the Constitution give us the right to determine these questions for ourselves. So, pretty bluntly, this is Brewer saying, am I out of time? I see somebody waiting. Yeah. Let me wrap up. Pretty bluntly, Brewer is saying, my understanding and the Fuller Court's understanding of the police powers are really derived from this language in the Declaration, and then kind of incorporated into the U.S. Constitution through the 14th Amendment. And we start from the proposition of not per se trying to find and name individual rights, but rather from the proposition, what are the limitations on the government's power? And those limitations are, frankly, that from Brewer's perspective, that the government does not have the power to impose any irrational or arbitrary laws, period. So if we reframe the constitutional issues this way, if we sort of leave behind what has become a predominant, what I think of as a rights-first way of thinking about liberty, and if we start, as Brewer starts, with the free political understanding of people as moral agents who have essentially unfettered freedom, who, for the common good, give up some of that unfettered freedom and institute amongst themselves a government of limited powers, then I think we can begin to think in terms of the boundaries of legitimate exercises of state police power. And essentially, I think, from Brewer's perspective at least, government power is only legitimate when it is the kind of power which absolutely free people would voluntarily give up in order to secure the common good. So in this sense, the Declaration for Brewer and what has become known as substantive due process is not really about securing specific rights to the people. It's about limiting the exercise of government power to only such acts as will reasonably, rationally, and equitably further the health, life, safety, etc. of its citizens. So arbitrary or irrational acts of the government which don't aim at the public good, but instead aim at some private benefit or restraint or beyond the legitimate police powers of the state. So at the end of the day, for Brewer, there's really only one grand overriding fundamental right, and that's the right to be free from arbitrary or irrational exercise of state power. And all of this thumbnail I've given you in kind of my brief conclusion, is not to draw any conclusions about the so-called rightness or wrongness of Lochner, of Brewer, of the era, or of any of that, but rather to simply, as a historical exercise, see what I think is kind of an intriguing example, as Hilton said at the beginning, of how what really started out as liberal ideas, at least that's how it would have been characterized in the day, really become dramatically changed as society progresses and has some pretty significant cultural upheaval. I think with that new perspective, seeing the law by Brewer's side, we can at least understand, if not agree, with his outlook. We can understand how he could rule the way he ruled in Lochner and view that as being consistent with his very progressive understanding of society and the role of the state and the role of judges. So that's actually, that ended up taking a bit longer than I thought it was going to get through everything. Josh, do we just need to end? Do we have time for a few questions?
I think we can take 2 questions. We'll go right into the next one, so feel free to take a break as we go in. But yeah, take a few questions.
So thank you very much. If anyone has any questions, again, briefly. Yes.
Excuse me, Justice Taylor. Are you sure Justice Brewer was not a father of Ayn Rand?
That would be historically, that would be an interesting discovery.
Like a page out of Ayn Rand.
So, Ayn Rand is that's what the question's about. I can't purport to know a lot about that and comment on it, but I will just say she is understood to be kind of a libertarian hero. And one thing that I did think as I was working through this is that the political philosophy that appears most probably relevant, to the extent we can impose in a backward-looking way any modern political philosophy on a figure in such a different era, it actually might be the libertarian philosophy. I mean, and that kind of drives the question.
I mean, she was in the 1920s, so she could have been inspired to.
Anyone else? Well, thank you very much, and I hope, if nothing else, this has at least revived a modicum of curiosity about a figure who I really think is unfairly neglected, and he is a great